Proposition 57. Criminal sentences, parole, juvenile criminal proceedings and sentencing, initiative constitutional amendment and statute. Plain language: reduce California's prison population by releasing lower-risk inmates and making it harder for juveniles to be tried as adults. The California Department of Corrections and Rehabilitation, which shall forevermore be referred to as the CDCR, operates the state prison system and is responsible for housing adults convicted of serious or violent crimes. In the case of criminal law, the terms serious and violent have actual legal definitions. An example of a crime labeled as serious is assault with the intent to commit robbery. Examples of crimes listed as violent are murder, manslaughter, rape, arson, domestic violence, kidnapping, battery, etc. But most crimes considered to be violent are also considered to be serious. The CDCR also houses inmates serving felonies that are not serious or violent, but who have committed serious or violent crimes in the past. As of June 2016, there are 128,000 individuals in state prison. Adult sentencing. When sentenced for a crime, judges hand down either indeterminate sentences, which have a minimum but no maximum, such as 25 years to life, or determinate sentences, which are fixed terms. Most receive determinate sentences, and many serve longer terms after time is added for additional lesser crimes committed in conjunction with the primary crime, or due to certain state laws, such as laws that require a term to be doubled if a felony is committed by someone that has committed a serious or violent offense in the past. Sentencing credits. State law currently allows the CDCR to award credits under certain conditions to prison inmates to reduce their sentence. The credits are provided for good behavior or for participating in work, training, or educational programs. Over 2/3 of inmates are eligible to receive credits, but state law limits the amount that inmate sentences can be reduced through credits. Juvenile justice. Youths accused of committing crimes when they were 18 are generally tried in juvenile court. However, under certain circumstances, they can be tried in adult court. Youths in juvenile court. Juvenile court is different than adult court. Judges don't sentence youths to a set term in prison or jail. Instead, the judge determines the appropriate placement and rehabilitative treatment. About 44,000 youths were tried in juvenile court last year. Usually, counties are responsible for youths placed by juvenile courts, and they are placed in county juvenile facilities. But for certain significant crimes, the judge can place the youth in a state juvenile facility. When this happens, the counties must pay for a portion of the incarceration expenses. Youths in adult court. In certain circumstances, youths accused of committing crimes when they were 14 or older can be tried in adult court and receive adult sentences. There are 3 ways juveniles can be sent to adult court. Automatically based on if the crime is serious enough, if the prosecutor recommends it based on the youth's criminal history, and at the discretion of a judge based on a hearing. Relatively few youths are sent to adult court each year. There were less than 600 such cases in 2015. What does it do? Prop 51 changes the state constitution to increase the number of inmates eligible for parole, authorizes the CDCR to award sentencing credits to inmates, and requires that youths have a hearing in juvenile court before they can be tried as an adult. More specifically, individuals who are convicted of non-violent felony offenses would be eligible for parole consideration after serving the full prison term for their primary offense. At that time, it would be decided whether or not to release these inmates before they have served any additional time related to other crimes or sentencing enhancements. One small caveat. While the law specifically defines violent offenses, there is no legal definition of non-violent offenses, so Prop 57 tasks the CDCR with determining which felony offenses qualify for earlier parole. As of September 2015, there were about 30,000 inmates that would be affected by Prop 57. In addition, about 7,500 of the individuals admitted to state prison each year would be eligible for parole consideration under this measure. Most commonly, this would involve individuals serving 3 years becoming eligible for parole or being released after 1.5 years. While the CDCR is already authorized to award some sentencing credits for certain inmates, Prop 57 would authorize it to award more credits and to more kinds of inmates. Prop 57 makes it so that the only way a youth could be tried in adult court is if the juvenile court judge in the hearing decides to transfer the youth to adult court. Youths accused of committing certain severe crimes would no longer be tried in adult court automatically or based on the decision of the prosecutor alone. Furthermore, prosecutors could only request that a youth be tried as an adult under 2 circumstances. The crime involves certain significant crimes listed in state law, such as murder, robbery, and certain sex offenses when the youth was 14 or 15, or the crime was a felony and the youth was 16 or 17. As a result, there would be less youths tried as adults. Fiscal impact. The fiscal impact of measures like this are always highly speculative, and nobody can really know how many crimes will be committed by who each year and what the outcomes will be. The legislative analyst bloviates extensively about how much money may or may not be saved or spent if more or less inmates end up in the state or county system, and if they're released early or not, and if they're tried as an adult or juvenile, and if they do or do not commit certain crimes after an early release, etc., etc., etc. You can read the handbook if you would like to bloviate, but for the purposes of this, I'll simply present the final estimation that the state would likely save tens of millions of dollars as a result of less people going to state prison, and the counties would likely lose a few $1,000,000 as a result of less youths being tried as adults. Before we continue, a special message just for you. Now available for the fall 2016 election, the Darryl Johnson Show Voting Aid, complete with titles and brief summaries of each proposition along with spaces for your notes and verdict for you to print out and take with you to the voting booth. It's completely free, no strings, no mailing list, no catch, just helping out the fellow man. Email TheDarrylJohnsonShow@gmail.com. You can write me cute little notes if you like, but to receive the guide, all you have to do is type Voting Aid in the subject line and the power is yours. And now back to our regularly scheduled programming. From Yes on Prop 57. Prop 57 focuses resources on keeping dangerous criminals behind bars while rehabilitating juvenile and adult inmates and saving tens of millions of taxpayer dollars. Overcrowded and unconstitutional conditions led the U.S. Supreme Court to order the state to reduce its prison population. Over the last decades, California's prison population exploded by 500%, and prison spending has ballooned to more than $10 billion a year. Now, without a common-sense long-term solution, we risk a court-ordered release of dangerous prisoners. This is an unacceptable outcome that puts Californians in danger, and this is why we need Prop 57. Evidence shows that the more inmates are rehabilitated, the less likely they are to reoffend. Further evidence shows that minors who remain under juvenile court supervision are less likely to commit new crimes. No one is automatically released or entitled to release from prison under Prop 57. To be granted parole, all inmates must demonstrate to a parole board, made up of mostly law enforcement officials, that they are rehabilitated and do not pose a danger to the public. Prop 57 only applies to prisoners convicted of non-violent felonies. It will help fix a broken system where inmates leave prison without rehabilitation, reoffend, and then cycle back into the system. From No on Prop 57. The following types of criminals could be released under Prop 57 because its authors call them non-violent. People who rape an unconscious victim. Human sex traffickers. People who commit lewd acts against a 14-year-old. Hostage takers. People who commit hate crimes and cause injury. Prop 57 permits the worst career criminals to be treated the same as first-time offenders, discounting strong sentences imposed by a judge. Prop 57 effectively overturns key provisions of Marsy's Law, 3 Strikes and You're Out, Victims' Bill of Rights, and Californians Against Sexual Exploitation Act, measures enacted by voters that have protected victims and made communities safer. Thousands of dangerous criminals have already been released early, and we are paying the price. The violent crime rate was up 10% last year, and rape up 37%. Prop 57 would authorize the immediate release of thousands of criminals. Prop 57 places all of these new privileges and rights for convicted criminals into the California Constitution, where they cannot be changed by the legislature. Make no mistake, if Prop 57 passes, every home, every neighborhood, and every school will be less safe than it is today. Join district attorneys, courtroom prosecutors, police, sheriffs, crime victims, superior court judges, and community leaders in voting no on Prop 57. So the no on Prop 57 arguments seem quite exaggerated. Immediate release, human traffickers released. There is a parole board for this. But either way, I'm sensing a disturbing trend and I don't like it. Most people understand that we do have a prison problem, but there seems to be this covert dismantling of the justice system one by one by one. If you were here with me in 2012, you may remember Prop 36, where Californians voted to weaken the 3 Strikes law to let more criminals out early. I voted for that law because we really do have a problem, and the 3 Strikes law in its original glory was pretty intense. But then they returned in 2014 with Prop 47, which essentially did the same thing. It made it easier by downgrading drug crimes and thefts to help more criminals get off easier. I was a little iffy on that one and ended up leaving mostly neutral. Now they're back for more in 2016 to open the floodgates, so I'm implementing my own 3 Strikes law for election years. 2012 was Strike 1, 2014 was Strike 2, and now I'm out. If you vote yes on Prop 57, you are voting to make it easier for jails and prisons to parole inmates and harder for juveniles to be tried as adults. If you vote no, nothing changes. The Darryl Johnson Show says no on Prop 57.